నమస్కారం. దూరదర్శన్ యాదగిరి ప్రాంతీయ వార్తా విభాగం సమర్పిస్తున్న భారతీయ నూతన నేర న్యాయ చట్టాలపై ప్రత్యేక చర్చా కార్యక్రమానికి స్వాగతం. భారతీయ న్యాయ వ్యవస్థలో కొత్త శకం ప్రారంభం కానుంది. బ్రిటిష్ కాలం నాటి చట్టాల స్థానంలో కేంద్ర ప్రభుత్వం తీసుకొచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాలు జూలై 1 నుంచి అమల్లోకి రాబోతున్నాయి. ఈ 3 చట్టాలలో ఏకరీతి న్యాయ వ్యవస్థ ఉండేలా, సత్వర న్యాయం అందించేలా పలు కీలక నిర్ణయాలు ఇందులో తీసుకున్నారు. పలు అంశాలు ఇందులో పొందుపరిచారు. దీనికి సంబంధించి మనతో పాటు చర్చించడానికి స్టూడియోలో ఉన్నారు సీనియర్ ఐపీఎస్ అధికారి, CDTI డైరెక్టర్ రాజశేఖర గారు. రాజశేఖర గారు నమస్తే అండి.
నమస్కారం.
జిల్లా రాష్ట్ర స్థాయిలో ప్రాసిక్యూషన్కు సంబంధించి ఎలాంటి నిబంధనలు పొందుపరిచారు?
First of all, prosecution was not uniformly followed in across the country. For example, in CBI, there is a Directorate of Prosecution. Below him is Deputy Legal Advisor, Assistant Legal Advisor, Senior PP, PP, APP. Each CBI branch has its own PPs or senior PPs as the case may be. The same thing, almost the same set of kind of things in the National Investigation Agency. But in states, it differs from state to state. For example, in Telangana and Andhra Pradesh, it is the judicial officers or the advocates who holds the Directorate of Prosecution or the Deputy Directorate of Prosecution. In Madhya Pradesh, an IPS officer is holding the charge of DOP. In Uttarakhand, one ADG rank officer is working as a DOP. So to bring uniformity, ekrupa, in all over the country, the Directorate of Prosecution provisions have been changed. Number 1, for Directorate of Prosecution and the Deputy Directorate of Prosecution, a advocate who has served for 15 years or a session judge can only be eligible for Directorate of Prosecution or Deputy Directorate of Prosecution. Another one concept, the newly appointed post is section 19 BNSS, that is the Assistant Directorate of Prosecution is the new one, who for the eligibility he has to be worked as judicial magistrate of the first class, or you should have worked as 7 years as an advocate. So these things uniformity. Then what are their responsibilities and powers? Directorate of Prosecution can give his opinion on the cases which has to be filed, especially on appeal, which has more than 10 years of punishment. Deputy Directorate of Prosecution will monitor the cases from 7 years to 10 years of cases, whereas the Assistant Directorate of Prosecution will monitor the cases less than 7 years of cases. All these 3 officers work under the State Home Department. For further clarification, the High Court of Delhi, the public prosecutors or prosecutors will be appointed by the central government to clear any doubt, because Delhi is such that there is a legislative assembly, but the police is under the central government, and the public prosecutors now can be appointed only by the central government. That will prevent a lot of confusion that has happened in the Delhi High Court. So these are the things that has been changed in the Directorate of Prosecution. It will bring uniformity. Then the monitoring and the supervision of the cases where the state government feels that it has to be special. For example, if they want to go on file appeal on a case which has more than 10 years, then they can give it to DOP. If there is a 7 to 10 years or 3 to less than 7 years, then they can ask the Deputy Director and the Assistant Director respectively to monitor, supervise the cases. So there is one more layer that has been added so that effective prosecution has been done, because police investigation is not just investigation. The fruits and the good work done by the police can only be done with the effective coordination with the prosecution, how well they present in the court, how well the evidence, police evidence or the charge sheet has been presented in the court. So for this one, coordination with the prosecution is required, and with these 18, 19 and 20, these are the 3 provisions in the Bharatiya Nagarika Suraksha Samhita, which almost streamlines, brings uniformity, and make able and very efficient for the prosecution side to take the cases, because prosecution side always take on the side of the victim. So victim means always the side of the victim means always on the side of the state. So it is the state versus the accused. Yes. So who will take the cases on the state? Obviously the state government. On behalf of the state government, it is the prosecutors. So the prosecutors and the police have to work together in unison, and now the uniformity has come. It will be very effective for the coordination and also to the effective running of the cases in the courts.
Judiciary system lo న్యాయాధికారుల వ్యవస్థలో ఎలాంటి మార్పులు రాబోతున్నాయి?
Yes, of course there are high courts in many of the states. There are some benches in the northeastern states, conglomeration of the 2 or 3 this one. Apart from that, in the district courts, there are 3 types we can say. One is the district sessions judge. Earlier, district session judge, below him additional session judge, and below him assistant session judge. Now that assistant session judge under the district session judge is no longer there. So there is a district judge and there is assistant session judge. On the civilian side, there is no changes. Obviously, civil judge senior division, civil judge junior division, that is there. But on the magistrate side, obviously the chief judicial magistrate is the head. Below him is the judicial magistrate of the first class and judicial magistrate of the second class. Whereas in the metropolitan cities, there was earlier concept of additional chief metropolitan magistrate, metropolitan magistrate. These nomenclatures have now has to be changed, because there is no metropolitan magistrate as such now, because now the nomenclature will be very uniform across the metropolitan cities as well as in the rural districts. Secondly, different states have their own structure of judiciary. For example, in Orissa, there is a special division judicial magistrate in bracket cognizance, one who takes the cognizance. In some, only the chief judicial magistrate only put the committal of the case to the high courts, and in some for the sessions judge. In some cases, it is only the JMFC who will record the confession statement. Like their own, they have made their own parameters or their own structure in the states. But now with uniformity of the structure, appealing of the cases is easy, and the monitoring of the cases within judiciary by the sessions judge to the lower courts and by the chief judicial magistrate over the lower courts, and division of the work will be very easy, because now all the assistant session judge now either has to be transferred to the additional session judge or they have to be given to the chief judicial magistrate. So with this streamlining of the judiciary, it is very effective for the monitoring of the cases, for running of the cases. There are not too many courts now, but only few courts, but with the larger ambit and a larger scope and variety of the work that has been involved.
రైట్, టైమ్లీ జస్టిస్ సత్వర న్యాయం అందించేందుకు నూతన నేర న్యాయ చట్టాల్లో ఎలాంటి నిబంధనలు పొందవచ్చు?
There are 35 timelines that are included in Bharatiya Nagarik Suraksha Sanhita for the investigation, trial and prosecution. First of all, trial in absentia in an absconder and all those things, no trial can be started within 90 days. For example, if somebody is absent or absconding or proclaimed offender 84 section 484 of the BNSS. On the otherwise, for example, the speedy justice, committal proceedings, when the case which has to be trialed by the sessions court committed by the lower court, that is the magistrate court, now it has to be finished within 90 days, commitment of the proceedings, extendable to 180 days with reasons recorded in writing. Framing of charges, it has to be finished within 60 days. Then plea bargaining, which has to be there 30 days, within 30 days the accused has to file a plea bargaining this one. Then also there are other this one, for example, mercy petition, it has to be filed within 30 days before either the governor or the president. If he first submit to the governor, then only 60 days is available for him to produce his report to the president or give his application to the president. So there are so many timelines in the Bharatiya Nagarik Suraksha Sanhita. Already we see 48 hours of the search and seizure, you have to produce it to the court of the seizure and report. And very importantly, even the judiciary has a timeline. So not more than 45 days in the lower courts, the judiciary has to give its verdict from the last date of its hearing. In the sessions cases, 30 days they have to give the judgment, not later than extendable up to 45 days with reasons recorded in writing. See, even for judiciary there is a timeline in this one. That means justice cannot either be delayed or not denied, because sometimes you always say justice hurried is justice worried, because if you run the cases very suddenly, there is a chance that you lack out some of the important evidence. On the other hand, you cannot drag the cases for long 10 years, 15 years like that. Now with these timelines, it is very important that the speedy justice has been done in these cases. Even for FIR, now 72 hours you get a document. Prosecution also, they have to run well third day. For the medical legal report, now within 7 days the rape victim's medical report has to be sent. In other cases, it is shall without delay. The word shall has been added. So these are all the provisions that makes a very effective functioning of this one. 14 days days to produce the documents to the accused. Within 14 days you have to give it to the accused. And already told, any witness, any document has to be produced before the court. 30 days is the time where it has to be either disputed or it has to be accepted, otherwise it deemed to have. 120 days for prosecution sanction. Now whether the prosecution sanction comes or not, above 120 days it deemed to have been given. So the timelines, really these deadlines or the timelines will make it that the investigation faster also. Now in the earlier cases the investigation go on and go on and go on. Now for further investigation 90 days only. Apart from that, you have to take the magistrate's permission to investigate the case. Of course, in POXO cases, rape cases, it is the 2 months that is their time. And in SC/ST cases, there is a law that there should be a day-to-day trial. In Prevention of Corruption Act, there is a day-to-day trial. So all in all, even in this Bharatiya Nagarik Suraksha Sanhita and Bharatiya Nyaya Sanhita cases, these timelines has made a very effective functioning of the courts and all those things. And with audio, video and with videography and in place, we can say that the effective disposal of the cases is very much can be done in this Bharatiya Nagarik Suraksha Sanhita.
పోలీస్ అకౌంటబిలిటీ ఇందులో చూసినట్టయితే వీడియో ఏదైనా సోదాలకు వెళ్ళినప్పుడు వీడియోగ్రఫీ కంపల్సరీ అనే ఒక నిబంధన కూడా పెట్టారు.
Yes. Now compulsory search and seizure videography has to be done. Earlier, some of the mistakes done by the police officers, they do not offer body search when they go for search and seizure. That's why planting of the evidence by the police officers was one of the complaint against them. Now you have to first videography the whole proceedings. There in the videography it is clear that the independent witness signature has to be there. The seizure search has to be prepared, that seizure memo has to be prepared in the place where the search and seizure takes place. Thirdly, within 48 hours after the conclusion of the search, it has to be sent to the jurisdictional magistrate. Now when it comes to videography, after the videography comes, that there is a chance that it will become a part of the final report. That's what we call it usually as a charge sheet. In section 173 of the CRPC, now it is section 193 of the CRPC. With all this, because earlier police was to do, they go to the search of place, they do not offer body search, then there are allegation that they implanted the evidence. Secondly, there is a niyam, that rule that one of the inmate has to compulsorily accompany the search team. Thirdly, as far as practicable, the decency and order of the materials kept in the house has to be maintained. But these were not made. Hurriedly, everything has been taken by the police, come to the police station and do their seizure memo. There you call the independent witness, there you call the house owner, there you prepare, and you prepare at any time you want. But now that is not possible. Even if you are conducting multiple search under section 165, now it is 185, you give the authority to the other sub-inspector and all those things. After all they assemble, then next 48 hours, excluding the time taken for journey, you have to produce before the jurisdictional magistrate whatever the seizure and all the spin that has been done. So yes, this is a very good aspect, that especially this one, and also it is a challenge for the police. Now they have to go with a proper videographic material or even by a mobile phone. Then if it is done in a mobile phone, they have to download the videographic clip, they have to produce this to the court, and the court will see whether there are any lapses on the part of the police in conducting search and seizure, any human rights violation. All these things will come into the picture, especially with this concept of videography of the search and seizure.
Right. థ్యాంక్ యూ సార్. డైరెక్టరేట్ ఆఫ్ ప్రాసిక్యూషన్కు సంబంధించి, టైమ్లీ జస్టిస్కు సంబంధించి చాలా చక్కగా వివరించారు. థ్యాంక్ యూ సో మచ్ సార్.
నమస్కారం.
కేంద్ర ప్రభుత్వం తీసుకొస్తున్న 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాల్లో డైరెక్టరేట్ ఆఫ్ ప్రాసిక్యూషన్, టైమ్లీ జస్టిస్, సత్వర న్యాయం అందించేందుకు దేశవ్యాప్తంగా ఏకరీతి న్యాయ వ్యవస్థ ఉండేలా చూసేందుకు వీటికి సంబంధించి రూపొందించిన అంశాలు, వాటి గురించి వివరాలు తెలుసుకున్నాం కదా. భారతీయ నేర న్యాయ చట్టాల్లోని మరొక అంశంతో మళ్ళీ కలుద్దాం. నమస్కారం.